So I'll just kick things off here while people take their seats. Got a great panel here. I'm going to quickly introduce them and then get right into the questions. I'm Teddy Downey. I'm the executive editor at the Capitol Forum. Joined by the great Seth Bloom. He's president and founder of Bloom Strategic Counsel and an old friend. And he used to be Senate Antitrust Subcommittee and now has his own practice. Also joined by Gus Hurwitz, assistant professor of law and co-director of Space, Cyber, and Telecom Law program at Nebraska College of Law. And his work builds on his background in law, technology, and economics to consider the interface between law and technology and the role of regulation in high-tech industries. Really pleased to have him all the way from Nebraska. And also, last but certainly not least, and probably doesn't need any introduction here at American University, but Jonathan Baker, research professor of law at American University, Washington College of Law. He specializes in the areas of antitrust and economic regulation and is particularly an expert on the topic that we're discussing today, and really want to thank him for helping us organize this and get this beautiful space. It's just been an incredible day, so thanks again, Jonathan. And so I'll just kick things right off here. We've heard a lot of different comments and some debate about which facts and arguments are really going to determine the outcome at trial. We heard some about the departure rate, efficiencies arguments, the efficacy of baseball-style arbitration. And Jonathan, why don't we start with you and your home court advantage here. What are the outcome determinative considerations at trial here?
So thanks, Teddy, and thank you to the Capitol Forum for inviting me. I hope you all are enjoying our new law school building. And it's also very nice to see Karina, my former student, come back with the program in the last panel, too. Let me say a few things about what to look for at the trial. And it's hard, even with the briefs, to evaluate the two sides' cases without seeing really all the evidence, but the briefs do give us some clues, as you heard from the earlier discussion. And I made a list of about 2.5 main factual battlegrounds and 3 main legal ones that I just want to touch on in a few minutes. So the first factual issue is about the magnitude of the harm from the vertically integrated firm's incentive and ability to negotiate higher programming prices to DirecTV's rivals. And both sides agree on the theory here, and it's well established in the economics literature and in enforcement practice. And not only that, as applied to programming and the kind of issues at stake in this case, it was validated by the Federal Communications Commission in Comcast NBCU. And you'll see in the technical appendix to the FCC's order, there's a discussion about how in a prior case we looked at whether the predictions of the bargaining model worked out, and why yes, it did. One problem for AT&T with here about saying the harm is small is it's hard for AT&T to, and this is what Steve pointed out earlier, Steve Salop, it's hard for AT&T to say the Time Warner content is really valuable, so DirecTV can do a lot with it after the merger, and that we, AT&T, will pay a lot for it, and then also simultaneously say, well, the subscribers of these rivals won't care if it's gone. That's a general optics kind of point. The technical details are hard to evaluate from the briefs. There's a little bit of back and forth on some of the technical issues, the departure rate, but you notice that on that particular one, the departure rate, the Justice Department appears to be relying on a survey from what I think is a marketing professor at MIT, and AT&T doesn't talk about that survey in its brief. AT&T's biggest argument here is about other type of argument here, not just the technical details are wrong, is AT&T says, well, our no blackout arbitration commitment would undermine the theory of harm. But AT&T may have a difficult time convincing the judge that that condition's enforceable in practice. There's no, FCC here, and Hal didn't quite get it right before, Hal Singer. It's not just an ALJ decision at the FCC. There's also a commission review before where the draws on the expertise of the agency there too. And so not having, there's more to it than just an arbiter and a law clerk or whatever he said. And he has to convince the judge not only that it's enforceable, but that the judge shouldn't care about competition after 7 years, that he shouldn't care about harms to virtual MVPDs or to streaming video demand providers, which AT&T says are growing competitive constraints. And not only that, and this I think Steve Sal pointed this out too, if this kind of commitment will solve the problem, why couldn't the baby food merger have been saved by giving a price guarantee to the supermarkets to let them enforce by arbitration? This arbitration remedy, no blackout arbitration commitment, has issues that AT&T has to confront. The second main factual battleground, and I'll say less about all the rest of them, so I don't take up everybody's time, is
the points we want to make.
Our efficiencies merger specific. The elimination of double marginalization probably is merger specific, but Justice Department says it's small, and that's plausible given that Turner's already everywhere. AT&T also has to explain why it can't negotiate a joint venture to facilitate targeted advertising. Why the two of them just couldn't do that with a joint venture? What do they need to merge for? The half factual battleground, I said sort of 2.5, is about coordination. And I can only say it's half because it's not highlighted in the briefs. But even though it's not highlighted in the briefs, it could be important. There was a recent merger trial where the litigation emphasized unilateral effects. And coordination was it was in there, but it was kind of an afterthought in how the case was litigated, but that's how the judge found for the government. All right, so then there are three main legal battlegrounds, and I'll do this quickly too. The first is, should a court presume that vertical integration is pro-competitive? Well, there's no good economics reason to do that. There are a lot of studies that find harm from vertical integration, a lot of recent studies particularly, in the kind of oligopoly markets that we see in antitrust, not obviously competitive markets, but these oligopolies. But there are many, and I kind of suspect Gus over here is going to say that he believes this, but there are a number of commentators who believe that vertical integration ought to be presumed pro-competitive, but there's actually not a sufficient basis to do that. Second, will the court require that the government prove a high market share upstream or prove upstream foreclosure? And AT&T sort of suggests both as part of the government's burden in its brief, but those are not ideas that are tied to the kind of harm here. They're not tied to the theory about the negotiating leverage getting increased as a result of the merger and as the mechanism by which prices are going to increase. So it's not obvious why the court ought to require these that AT&T suggests. And then finally, will a court require proof that consumer prices increase generally, or at least that AT&T itself will raise the direct TV price to consumers? And those things are in the brief too, and I'm skeptical here too. It's enough to raise the price of programming to the buyers of the programming, to the MVPDs, et cetera. That was in the baby food merger that I was mentioning before. The harm to the wholesalers, the court said, was enough. You didn't have to prove harm to consumers. And not only that, even if we're going to care about the downstream consumers legally, if you raise the cost for every rival, of course downstream competition is harmed. And courts recognize that in other contexts. If you look, and finally, the issue is basically the average price in the market as a whole, not AT&T's price. If we're interested in what is happening downstream, it's really irrelevant whether AT&T takes its market power profits in the form of Time Warner makes more money and DirecTV expands its market share, or whether it takes them in the form of DirecTV gets the raised price too, or both.
Okay, so Thank you for having me here. I will say we might have an FTC deception claim. I love American University because it's on Nebraska Avenue, and I might have been a bit confused about where I was going. No, that's a joke. I'm thrilled to be here. I have the unenviable, though slightly more enviable position than Seth's position of speaking following the wonderful summary that we just had. So I'm going to speak a little more briefly, in part because I have less to say, but in part because much of what I would say has already been covered, and also I think the really interesting, challenging parts of this discussion are probably going to be on the policy side, the implications of this case, depending on how it gets decided. So I want to focus on just a couple of key legal issues that the judge is going to need to decide in deciding this case and figuring out how to proceed. I want to start with the burdens of proof question. And I'm going to kind of say what Jonathan suggested I was going to say, but in a different way. We have not had a litigated vertical transaction like this in many, many years. We have had several horizontal transactions that have been litigated. So there's a question that the judge is going to need to figure out. How do those standards that have been applied for adjudicating horizontal transactions apply in the context of vertical transactions? And the most important aspect of this is, in the context of horizontal transactions, we know as a matter of empirics, as a matter of theory, and as a matter of how the law has evolved, that if we see market share increases, if we see HHIs go up, that there is some reasonable presumption that can be drawn from that, that bad stuff will happen to consumers. The fact of just proving the government's case that, yes, this transaction is going to occur is going to be enough to push the burden to the defendants than to say, but it's okay in this case for reason X, Y, or Z. That doesn't necessarily apply, I'll change that. That does not apply in the context of vertical transactions. I am one of those individuals who would carry a presumption that vertical transactions generally are pro-competitive, pro-consumer, pro-efficiency. But the question in this case really isn't, should the court presume that vertical transactions are good by default? The question is, should the court apply the presumption from horizontal transactions that horizontal transactions are bad by default, shifting the burden to the defendants to show that the transaction in question is good, or instead should the court apply what I think would be the more traditional burden of saying the government bears the burden of persuasion and needs to demonstrate that the transaction in its entirety is bad. And once it's done that, the burden shifts to the defendants. We'll also see related to that some interesting discussion and legal questions about what is the role of efficiency in this case. The last point that I'll make that we see the parties already in their pretrial motions arguing is, what's the meaning of likely, or likely to substantially lessen competition? The parties have very different understandings. AT&T is emphasizing, italicizing, underlining the words likely and substantially. The government is arguing that substantially lessen competition means something a little less, drawing again from existing precedent from the horizontal context, point to language like there's an appreciable danger or a reasonable predictability or probability that competition will be substantially lessened. The fascinating thing for me about this discussion, and this will be a little out of left field in the antitrust context, is the Federal Trade Commission has a big case right now relating to its Consumer Protection Authority, LabMD, where much of the litigation is over what does this word likely mean. And when statutes use words like likely, and here we don't have likely, we have may instead of likely. But when we have words like this, there's a lot of legal indeterminacy over how likely does something need to be in order to be likely? And do we put the emphasis on the likelihood that competition will be lessened or the magnitude of that lessening? I would expect some important legal analysis and outcome of this case based upon that analysis that will have impacts in future litigation.
Perfect. Seth?
Thank you, Teddy. Thank you for inviting me into American University, and it's a beautiful building. So I'm conscious that I'm the third person on the third panel, and as my former boss, Senator Herb Kohl, used to say, everything has been said, but not everybody has said it. So I will try, when he was talking about Judiciary Committee hearings as they went on, I will try to perhaps, hopefully, say something new, but I can't guarantee it. And I'd also like, that was an excellent, I think, presentation by both of my predecessors on the legal issues. I'd like to talk a little bit about the factual issues, although they were touched on a little bit. So, what are the key issues? I think it's in the government's brief, and page 3. And they say, the critical question is this: would consumers quit subscribing to AT&T's competitors and switch to AT&T, and that by that they mean DirecTV or Uverse, and switch to AT&T if they did not carry Time Warner content, thus allowing AT&T to increase the price of that content? In fact, in the defendant's own words, the Time Warner content is more than significant. Time Warner content is a must-have. That's what the government contends, and I think that's the crucial issue here. Now, also, I think it's interesting in the government's brief, they say, before they say what I just read to you on page 2, the AT&T's defense is a Star Wars defense. Everything the government is telling the court is stale and out of context. It is from a long time ago in a galaxy far, far away. I think it's very well put. But you know what? Despite the government's effort at mocking AT&T and the defendants, I agree with the Star Wars defense. And I think, and you asked me to highlight the issues, but I'm going to say a little bit of my views too. I think what the government is asserting here is quite a dubious proposition. That's the key issue they've got to get through, but it's quite dubious. So they're saying consumers are going to so demand the Time Warner content that if they don't get it, they're going to switch to the AT&T properties, or they'll pay a price increase that AT&T is going to impose. Let's think about the Time Warner content. Well, but before I get to that, one thing interesting noticed absent from the government's case and complaint is any notion that there's a fear that independent programmers or non-affiliated programmers are going to be discriminated against in the AT&T platforms once the acquisition takes place. I found that to be very interesting because in earlier content distribution mergers, that was one essential element of the antitrust claim. It's absent here. So all we can focus on is the Time Warner content essential, and can AT&T deploy this content in a way to cause consumers to switch to AT&T or raise the price and cause consumers to pay more? But let's think about the AT&T, the Time Warner content. Well, in the main here, we're talking about our networks like TNT, TBS, Cartoon Network. You're telling me that consumers are going to say, oh my God, I can't get my movies on the Turner Classic Movies, so I got to switch, or I'm going to pay a lot more to get this. I got to switch to DirecTV. I mean, I think that totally ignores what's been going on in the last 5 to 10 years in the way consumers view content. And consumers with a plethora of choices through things like Netflix and Hulu and Amazon Prime, to name a few, they're cutting the cords. AT&T has a statistic that 22 million consumers have cut the cords by the end of 2017. That's their statement. I don't know if it'll stand up to the factual inquiry, but clearly cutting the cords. We're here at American University. Do you think how many American University students or recent graduates, millennials, have a cable subscription or a satellite subscription? People don't view content this way anymore, or by and large, and many younger people don't even have televisions. They're watching their content or they don't rely on their television screens. They watch the content on mobile devices, iPads, on phones, and so I just think this. I do think this is from a galaxy far, far away. I think if this case was brought 10 years ago, different story. But I think the government's it has a major burden, and whatever I think, it maybe doesn't matter. But this is the key legal issue. They've got to overcome in the case. AT&T's saying we can't withhold content because we're going to lose millions of dollars, tens of millions of dollars in subscription revenues, if we're talking about something like HBO, advertising revenues, or licensing revenues from a traditional network. We can't do that, and so it's going to be the government's burden of proof to say that it's more profitable to raise the price because consumers will switch to AT&T or pay more. And you notice when I first, you may have noticed when I first spoke, the most powerful thing that Time Warner has is HBO. I mean, shows like Game of Thrones. I mean, those things I will concede clearly are must-have programming for a cable package. But AT&T Time Warner already markets HBO to consumers without a subscription on HBO Go. So is the government saying that once AT&T takes over Time Warner, they're gonna drop HBO Go? They're not gonna market it directly to consumers anymore. It actually has 5 million subscribers, up from 2 million subscribers in a short period of time. Again, I just think that's not a credible position. So it comes down to the other networks of Time Warner, the Turner networks, TBS, TNT, and the rest. And I just don't find that's a compelling reason that consumers will switch. In any event, as I said, to DirecTV, as I said, it's not what I think, it's what the government has to prove at trial, and I think the government's gonna have quite a burden on that, to do that. So,
Can we stick on this point
Okay.
and then come back? 'Cause
Sure.
I'm not sure if Seth watches sports. But,
I do watch sports, believe it or not.
Jonathan, can you maybe quickly, because I want to stay on departure rate, but you're also bringing up this idea that it's not must-have content, which I don't think is really that quite as disputed. I mean, I want to get into. We haven't debated it yet. So,
Okay.
Jonathan,
Can I address the sports? Or I didn't take away your question, but I.
All right, well, just yeah, you can.
Okay.
Yeah.
So and then obviously Jonathan can talk about it. We talk about sports. So AT&T has statistics in their brief, and I'm relying on their statistics, and they're going to have to establish that in a trial. But they claim that now I'm looking for it. I'm sorry. They claim that their sports programming is not very compelling, and it's a small part of the sports universe. I think it's 6% of the sports viewing universe. Unfortunately, I don't have the statistics in front of me, but. Only 12% of the highest rating sports programming is on the Turner networks, and it's a small amount of sports. So I can plug in specific content out of specific statistics out of the brief. But I think they would say their sports programming is not very compelling. So that's basically my response on that.
Yeah, I'd just like to kind of quickly stay on this idea of departure rate because it came up as a huge point of contention.
Okay, let me just finish this and then I'll stop talking. Here's this, on page 51 of their brief. Overall, Turner has rights to only 1% of Major League Baseball games, less than 8% of NBA games, less than 3% of NCAA men's basketball games, and no rights to all of football, NFL, college, or hockey games. So that's I think. Yes, I think if they had a lot of sports programming, as other, like Fox does, then I think it would be a different story. But
So, Jonathan, I just want to say quickly, and Gus also, if you have any comments on this idea of departure rate and the must-have content, and then.
yeah, they have a few other points to make, Jim.
Yeah.
I'll say something about that. First, just a factual agreement.
Yeah.
Am I right that Turner has March Madness?
Yeah.
Yeah. So
And
I mean, it's not a question. Sorry.
Yeah, it's all.
And MLB playoffs, right? It's not just a question of the percentage of all the programming. Is it the programming the consumer has to watch?
For 2 or 3 weeks, I would say it's only 2 or 3 weeks, either March Madness or the baseball playoffs. So
You're not.
All right,
and consumers have
You're
alternatives.
gonna
to watch.
watch the whole regular season, but not the playoffs. I mean, come on. I mean,
Most
this is
people
just.
only watch the
We're not.
playoffs.
We can't spend too
but let me
much
say
time on that.
two other points about this area. One is, if you really believe that nobody is going to leave in the event that you go dark on Time Warner content. Time Warner has zero bargaining power. They wouldn't get any money. Any profit at all. All the surplus would go to the MVPDs. That just sort of seems like an exaggeration of how the market works. And finally, just to get back to the departure rate, there's a lot of back and forth about what to learn from examples in the past where where programming went dark, and then what happens to subscribers. And those are kind of tricky because they tend to understate what you'd be worrying about here for the purpose of a bargaining model, because the examples of programming that they have are basically weaker programming, we think, than the Time Warner programming. And in general, a lot of these examples, the programming that going dark is temporary, and consumers probably understood it that way. And it's when it's permanent is what you'd really see the departure rate, and that's what's relevant to the thinking about the bargaining model. But even with all of that, there's still that I think it's Hauser study, the market that I mentioned before, that's in the DOJ brief, and I think it says that if a video distributor lost access to the Turner content, it would lose 12% of its subscribers, and that's pretty sizable, actually. So if that study holds up, there's a lot of concern about the loss of the Turner content.
I want to stay on this issue. Basically, like, you put yourself in the judge's seat, and you're looking at these arguments about departure rate. You know, we had a couple of comments before about, well, if it's not must-have content, why are the MVPDs paying $3 for it or $2 for it? Why'd they pay so much for it, the Time Warner, if there's no must-have content? So, like, if you're the judge and you're looking at the economics and the broader point about must-have, how do you make a decision? Is it all related to the economics, or is it, you know, how does that decision, how does he decide that?
Do you want me to say?
Yeah, everyone.
I'll just say very briefly that it's really it's a question of magnitude. You can't really say it's going to be zero or you know, it's a question of how much, and the judge has to think about the whole full range of evidence, and it's very hard to evaluate at this stage for us to evaluate, because the briefs don't really get into the full range of evidence that the judge will have before him.
Yes, so it's my understanding we have two dueling numbers. We have the 12% departure rate alleged by DOJ, and I think the other side number is about 5%. Very different. There is a departure rate. The question is, what is it? How is the judge going to think about this? I think that my inclination is that the judge is probably going to be more favorable to AT&T's numbers. The reason for that, and again, we only have what's in the briefs, but it's my understanding that those numbers are more likely derived from internal documents, internal estimates that AT&T and other companies have done based upon prior incidents, as opposed to the Hauser study, which is less based upon actual internal numbers being developed for business purposes. So if that is correct, if I were the judge, I would say, well, the AT&T numbers are more likely accurate, less likely biased. Another aspect of this is how does the no blackout arbitration proffer play into this? And one important hot doc sort of statement that the DOJ likes to point to are the statements from DirecTV and prior investigations about how harmed they would be by acquisitions. DirecTV, in those statements, discussions, basically said, but if an arbitration agreement such as AT&T has put forth here were in place, we wouldn't be harmed at all. So that's going to take a lot of the wings out of that factual statement that I would have otherwise, and I still expect a DOJ would rely on substantially.
And if I can take a crack on that, I mean, I think there's two ways. One is they talk about past examples, and in the AT&T brief, they talk about Suddenlink dropping Viacom, 24 Viacom channels in 2014, and they say lost only 5% of subscribers. And then there's an incident of June of 2013 where Cable One dropped all of Turner, but that was only 23 days. I think Jonathan's point, that's a temporary thing. But in that case, there was less than a 1% loss of subscribers. So they'll talk about that, and the judge will look at that. But I think I'm going back to my original point. The market's changed. So, you know, and this is a forward-looking inquiry here. The judge has to assess if in the reasonable future, what's gonna happen, what would happen if Time Warner content went dark. And I just think the market in 2018, in 2019, in 2020, and going forward is a different market than it was even with that study and even with these examples. And so I think you look at statistics like cord cutting and you take cognizance of the fact, if I was the judge, of what's going on today in the market and what's likely to happen and where are the trends. And I'll stop because I'm talking like a broken record, but are people insistent on getting TNT through their pay TV provider, and if they don't get it, they're just gonna say, forget it, I gotta switch to DirecTV. That might have been the case 10 years ago. I just don't think that's the case today with all the alternatives that people have to get that content or competing content. So on online viewing without a cable subscription. So, but this is, what you asked is the key question. I was gonna make a broader point too, so I don't, I think another key issue is we have this economic theory, proffered by the government, Carl Shapiro, based on a Nash bargaining model. It's great. I mean, economists will love that. But how will a judge looking at a real-world case take that into account? And what kind of evidence does the Justice Department have to bring to support that beyond the testimony of its economists? And what kind of evidence by AT&T could refute that? And I think the role of economic theory in this is a key issue that the judge is going to look at in this case.
Actually, yeah, go ahead.
I just have one last point I want to highlight about the arbitration offer, which is the no blackout part of it. That's huge when you're talking about the possible diversion ratios and loss rates here, because when do we see blackouts? When do we see these high-tension negotiations? It's right before the World Series. It's right before the playoffs when we have this big issue coming up, and the content provider knows, hey, this is the chance for me to black out the content on the MVPD, on the distributor's network, because I have a ransom there. And if the agreement is I won't do that, that dramatically weakens the bargaining power, even beyond just the binding arbitration provision.
But that assumes that it's enforceable.
Yeah. Yes.
Okay, any other, I want to get into the sort of the future of the law and policy, but any other thoughts on, that you want to make on what the outcome determinative factors are here, before we move on to that? We covered it. Let's move on. We can always take questions. So you sort of get wide range of opinions when it comes to how big of a case this is. Some people are saying, if DOJ wins, there'll be no more vertical mergers, and they'll go back and unwind Comcast, NBC, and everything's going to change. If on the flip side, if DOJ loses, there's going to be a huge wave of mergers, and there's no way they could ever bring any kind of vertical cases again. What's really at stake here? What's really going to happen? Is DOJ kind of, are they past the point where they're just like, they're gonna look at all these vertical mergers skeptically, or is this really gonna determine how DOJ thinks going forward?
So can I take a crack at that first?
Yeah, go ahead.
So, I think you meant to say if DOJ loses. You said if there'll be no more vertical merger cases at the beginning.
Sorry.
I mean, I think it's interesting. This is the first contested vertical merger case brought to trial in 40 years by the DOJ. I think it does make us rethink, the viability of bringing vertical merger cases. But I will say, it's true, and this is sort of a boring answer, but that every merger is decided on its own merits. So you have to be cautious about saying, well, this is so going to change the landscape so much. Having said that, I think if DOJ loses, that does put a deterrent to DOJ and to Make and Del Rahim and others to bring another vertical merger case, because they certainly don't want to bring cases that they're going to lose. And if there's a precedent set here, and there's going to be some important precedent set here, I mean, it's only one federal judge in one district court, but still, that'll put some caution the next time somebody from the staff says, let's bring this vertical merger challenge. I noticed that 28 staff members signed the complaint, which I found to be a high number of staff members. It was probably sending the message that this wasn't a political action. This is really well supported by the staff. But it's always going to be a decision, a completely discretionary decision by the Assistant Attorney General, whether to pursue a vertical merger case. And so if the DOJ would lose, I think that's one obstacle, one significant obstacle to pursuing other vertical merger cases. If the DOJ wins, I'm not so sure, what that means, because I say every case is decided on its own merits. And I wouldn't say, well, this means there's gonna be a floodgate of vertical merger cases. I think the bigger danger, the more significant outcome for the DOJ would be if they were to lose this case.
Yeah.
Just down the line?
Okay, go for it.
So I'll possibly somewhat disagree with that. I think if DOJ wins this case, and depending on how the judge evaluates the facts, we're looking at deeming a vertical merger to substantially lessen competition, largely based upon a predicted 0.4% increase in consumer prices. It will almost, I would say, create a per se bar against vertical mergers. It would make it very easy for DOJ to challenge vertical mergers in the future. If DOJ loses, it still is going to be case by case. We'll know a lot more about what the standards are moving forward after this case. So I'm less concerned about how this will affect the legal standards generally if DOJ loses. I think it is a really good thing that we are seeing some litigation of a vertical merger, because I think we do need more legal certainty as to what the standards are. I think this is a bad case to have been brought, to be pushing those edges. A couple other points that I would make. First, if this litigate the fix technique works, it's going to fundamentally alter the relationship between DOJ and merging parties moving forward, especially in vertical mergers. It seems like there could be we're talking about the bargaining model. That's the key econometric tool here, and a bargaining model. Well, the bargaining model between merging parties and the DOJ will significantly change as a result of this tactic. There is much less incentive, I think, for parties to engage in fulsome negotiations with DOJ before DOJ decides to bring a challenge. Instead, wait to see what the DOJ's model says. And in vertical transactions, I think there's a pretty good opportunity then for parties to say, well, this model is based upon assumption X, Y, and Z. We're going to make commitments that undermine those assumptions. Your model just got thrown out the door. That could be a dramatic change. I won't get into my thoughts right now. Hopefully we'll have a chance on how this all ties into the use of and the role of behavioral remedies. But I both very much agree with Delareem about the problems with behavioral remedies, but I also believe that they have a very important place in these transactions as a form of soft law protection that indicates to Congress, indicates to consumers, indicates to other federal agencies, and indicates to the market what sort of behavior is likely to be problematic or receive attention in the future.
So my take on the policy implications goes like this. Suppose the Justice Department loses. What the implications are depends on how it loses. So suppose the Justice Department loses on the law and the court adopts the presumption that vertical mergers are pro-competitive, that would be a big deal. That would change the law in a way that would encourage vertical mergers. But if the Justice Department doesn't lose on the law, but just loses on the facts, you just haven't proven your case on some of the technical details, well, this is just one case, and you can bring the next one and show on the facts something different, and maybe it'll be stronger on the facts. So that's not a huge policy deal. And finally, if the Justice Department wins on liability but loses on the remedy, and the judge just accepts the conduct conditions, well, again, that's just one case too, and the Justice Department can try and argue for the remedy in the next case. And then finally, on the flipping it around, if the Justice Department wins, I think what that'll do is encourage the Justice Department to avoid, to stay on its course of emphasizing structural relief rather than conduct relief. I disagree with Gus. I don't think that somehow will turn vertical mergers into per se illegal mergers. For one thing, the judge is going to, is likely to have, if he decides for the Justice Department, he's not going to say, oh, there's this teeny tiny price increase, and that's good enough for me. But even if he did, there's no de minimis exemption, under the Clayton Act. Even a merger that's a small harm, whether it's horizontal or vertical, is technically illegal. It's really more a problem of when the harm is going to be small, it isn't worth the resources to bring the case if you're the government, and it's really hard to prove that it's not zero if you're the government. So there's no practical danger that that if the government wins, this will somehow make all vertical mergers illegal, which is what I heard Gus to be suggesting.
And in fact, this deal could have gotten done if there were structural changes.
I mean, if structural relief were allowed, if conduct relief if conduct relief were allowed by DOJ, on the model of Comcast Time Warner, Comcast
at least
MSU.
according to our reporting, if they had offered to divest
Oh.
the must-have programs, the deal would have gone through. So there was one other, and I'll open to questions momentarily, but one of the points you made was about this definition of consumer needing to be the end consumer versus the MVPD in this case. That is something that we're seeing being made in other cases. I think in the in the credit card case that's being made, and there's a huge question about, okay, if you're talking about the end consumer now, what does that mean for consumer welfare? I mean, is that a big point of contention here? And is that a big deal that you're going to change the definition of consumer to mean end consumer as opposed to the MVPD here?
I'll talk eventually, but
Yeah,
I think that's an excellent doctrinal point, and the point you made on that, Jonathan, was excellent. I think other cases, we're seeing it in the healthcare field. We'll see that argued in CVS Aetna with the Cigna Express Scripts. What are we concerned about the end consumer, or are we concerned about these middlemen and the effect on that? So yes, that's a major point, I think.
I'll just say I honestly have not thought a great deal about this, other than that I very frequently find myself puzzling through indirect consumer issues in other cases. So there could be fascinating stuff there. I would say this is a starkly different case than the two-sided market issue at the core of Amex. So I don't think that there's a meaningful juxtaposition there, but the question is important.
And I'll say that I don't think that's the law right now. That I think if there's harm to buyers, the immediate buyers, that's plenty good enough under antitrust law. If you start requiring that courts look to how everything gets passed through to ultimate consumers, not only is it impractical, it is also inconsistent with the requirement in Philadelphia National Bank, where you're only supposed to look in the market where the harm is to think about the trade-offs of efficiencies and harms and benefits and things like that. And so it would, and so I think it would probably raise an appealable issue if the court were to decide it on that basis, and then ultimately a Supreme Court decision that were to decide the case on that ground and require proof of harm to ultimate consumers would change merger law and merger practice a great deal.
Go ahead.
I was just going to ask, I hope that we can ask this question, what we think is going to happen moving forward, whether this will be appealed, whether this will get to the Supreme Court. Generally, when we're talking about these cases of a century, I will confidently say I think this is the most important case that will be argued in the District Court of DC in March. But I don't know about if it will be the case of the century. The role in the broader antitrust appellate ecosystem, I think, is a fascinating question.
And can I just respond to one thing Jonathan said? I agree with you that the law isn't that if it's a buyer is suffered, you have to look at the ultimate consumer. I believe the law is the buyer, whomever that buyer is. But that again goes me back beating my dead horse. So our MVPDs, cable companies, satellite companies, going to accept AT&T's demand for higher prices based on this content. Once again, I think that's the key issue. You've heard what I had to say about that. But that really, again, highlights, actually, there's one interesting thing in the AT&T brief, they say, and I'm not quite sure where they get this from, but they say the government is no longer arguing that AT&T will withhold Time Warner content from distributors. They say it's only now arguing that they're gonna raise the price. Of course, in the original complaint, the government argued that they would withhold. So that, we don't have access to the discovery that gave rise to that assertion. However, I will say this, it really doesn't matter, because if you're gonna raise the threat is that we raise the price, otherwise we'll not give it to you. So I'm a little surprised to see AT&T making such a big deal out of that.
What I conjecture is going on, but I don't, that there's this, at the FCC, in Comcast NBCU, for example, in earlier cases, there was a issue about the analysis was, well, are they going to withhold either temporarily or permanently, or are they just going to raise price? And the FCC had, prior to Comcast NBCU, just been looking at the withholding, and in Comcast NBCU, it added in the bargaining model and will it raise price? And the withholding analysis was, preserved there because it was a legacy FCC thing, but the way a modern economist would look at it is basically through the bargaining model, where it's the threat to withhold that gives you the bargaining leverage. So I kind of suspect, but without knowing, that this is just, they're saying our theory really is just involving the bargaining model. It's not this temporary or permanent withholding that the FCC was worried about also, in Comcast NBCU.
Well, let's open up for just a few questions before we wrap up.
Yeah, Dr. Baker, just a question on the Comcast NBCU. In your technical appendix, I shouldn't call it your technical appendix, but in the technical appendix, you talk about the elimination of double marginalization, that there is complicated sort of efficient contracts that sort of really get a very limited merger-specific benefit. Could you describe or elaborate what, the logic and the rationale for what those complicated contracts are? I mean, I know there's MFNs and all this other stuff, but why, what's the rationale for saying this?
I'm not precisely remembering what you're saying. I do remember there was an issue where
You said basically that the elimination of double marginalization was not a huge benefit,
right.
because,
But Steve is the one who remembers this better than me, so why don't we just let Steve answer?
The reason why the
Yeah.
EPM is so small is because they will get very few additional subscribers. So if DirecTV lowers its price, suppose DirecTV lowered its price, and all the additional subscribers it got already got Turner, then there would be no incentive to lower price in order to generate these extra subscribers, because they're already getting Turner. So that's a reason. And secondly, DirecTV gets a relative, as I assume, I don't know this, but DirecTV, since it's one of the largest national MVPDs, probably gets a fairly low price on Turner content. So therefore, if it diverts a customer from Dish to DirecTV, that's actually less money for Time Warner. So that's why I think it's small. See Moressi and Sal's vertical gut.
I like that. Hal?
Hey, so this is for Jonathan. Quick comment and then a question. Yes, I mean, everybody should weigh in. The comment is, you said that you think the full FCC commission is needed to review an arbitration decision by an ALJ or an arbiter. And I'm wondering if your opinion would change if you thought that AT&T had submitted to binding arbitration. If you think the binding aspect, and they've got a 30B6 witness who testifies that it is in fact binding, do you still think that the decision by an arbitrator would have to be reviewed by the full commission? And then one other question on that one too, if I could. You mentioned, I mean, that was more of a comment, but I would like to weigh in. But you said that you think the inquiry should end when the intermediary suffers injury. And I'm curious if you think there ought to be any requirements, or what do you think the law is on whether or not the injury or the price effect has to be material. In other words, we have a 27-cent per month figure from Shapiro in this first go-around. If that number were instead 1 cent or 5 cent, would you think that's sufficient to trigger a violation of the antitrust laws, or do you think there has to be some materiality or substantiality to the price effects?
All right, so on your first point, the reason I was talking about the FCC, I guess I wasn't making that clear, the commission review, is that's where I was pointing out that the FCC can bring agency expertise to evaluate the arbitration, the fuss of what the dispute was in the arbitration, and it's not just some random arbitrator or ALJ that's looking at the deal. The whole commission is in effect involved because there's commission review of what the ALJ does. So what is missing, even with the arbitration were binding, you still wouldn't get the benefit of the expertise that the FCC could bring to the analysis. And then on the second question, I think I'll just repeat quickly what I said before. I don't think there's a de minimis requirement in antitrust law for a violation. I think as a practical matter, if you thought the violation was tiny, you wouldn't bring the case if you were the government, and you wouldn't be able to prove it if easily, because it would be too hard to be precise that a small number is different from zero. So that as a practical matter, yes, but as a legal matter, no.
I think we had one last question. Steve?
I just wanted to ask Seth, he didn't answer John's question. John said, why do you say the departure rate, why do you say Time Warner wouldn't, the MVP wouldn't lose any subs? If that's true, why is Comcast willing to pay $3 a month per sub for Time Warner content?
Well, I don't want to speak.
It's just stupid?
No, and it's a client of mine too, so I will leave out any direct reference to Comcast. But why would an MVPD be willing to pay that amount? I'll answer that question. That's the way. I'm afraid I don't have a good answer for that. But that's the way the business. but I don't want to stop it there. The witness wants to defend his answer. That's the way the business has been doing it. But in any event, it's the burden of proof on the government to establish that. It's a burden of proof on the government to establish that this price increase is going to happen. So it's not sufficient, I think, if we're talking about this trial, it's not sufficient to say that they've been paying this much for this content. The government has to say that this merger is going to cause a substantial lessening of competition. It's going to cause a price effect, and they've got to establish that. So, I think you have to look at the issues that I brought out. By the way, as to your, and again, I'll go back beyond the burden of proof. People are dropping their cable and MVPD subscriptions. Perhaps that suggests evidence that they don't like paying that much for this content. If the content was so valuable, why would people be cutting the cord? Because millions of consumers cutting the cord because they realize that they can get similar content or maybe the same content from other means online. So I think that's my answer too. And by the way, just let me finish this.
Yeah.
All my views are my own, not representing any clients. So I just want to make that clear.
If it was such bad content and it wasn't that big of a deal, why wouldn't they have divested it? And
Well,
you
why
said,
would
you
they?
said the only thing is HBO.
Oh.
The only thing
Well, I
that
don't know
matters is
exactly. I don't know
HBO.
exactly what the government was asking.
Well, because you read the Capitol Forum.
Well, okay. I think the choice was divesting, as reported in the Capitol Forum, either divesting DirecTV, which they had just spent billions of dollars to acquire, or divesting all of Turner. Is that the reporting?
Yeah, I think that's right.
Yeah. Well, I mean, I think those were the reasons they did this deal, was to acquire either.
Turner here doesn't mean all of the content, right? There isn't it like the Warner, like a capture.
See, we don't know the exact dimensions of this settlement proposal, so it's hard for me to respond to that. Or
I'd just like to add, not directly responsive to the question, but the previous panel's discussion of the dynamic nature of this market, and maybe at some level what AT&T is doing is defensively buying up stuff so that it's in a better position to adapt moving forward. That might explain some of their reluctance to divest content, divest assets that might be important to their ability to compete moving forward.
Yeah, just to answer your question, Teddy, that if Turner's 50% of the EBITDA of the company, it's not as easy to say, like, we're gonna pay a premium for this company and then sell half of it off at a discount. Doesn't make any sense, right? And just because you're buying an asset doesn't mean you're buying it because it has illegal market power. It means you're buying it because you think that the transaction is attractive. But I actually have a question for Steve, which is,
I'll answer this.
In this B2B world, if you
You.
believe, like you're saying, $3 means that it's, must have, or that it's, really good to have, doesn't that mean that Turner, if it's something you must have, doesn't Turner already have the vast majority of all the bargaining leverage, and how would it be that just by,
It doesn't imply that at all.
why?
Because it just doesn't. I mean, the logic does not compel that Turner's own the bargaining power. It's just whatever the bargaining power is, they're splitting the surplus. But you're right, if Turner had all the bargaining power, if you believe that, contrary to what AT&T is saying in its brief,
I agree.
then there'd be no impact of the merger. On the other hand, if you take AT&T said Turner has hardly any bargaining power, i.e. it's getting less than 50% of the surplus, then the merger impact gets even bigger.
Right, but as a mathematical equation.
That's math, I was just-
Right, I know, but I'm saying if Turner, let's say if Turner has 80% of the bargaining power in this relationship, then the merger effect is gone, right?
Yes, yeah. All I was adding was AT&T said the opposite.
Yeah, I get it.
I think we had one other question, maybe before, to wrap things up. Did we have one? No? All right, well, this is a great conversation, a great way to cap off the event, so thanks for everyone for coming.